Commission.
Lord Mance will explain the judgment of the court.
The Supreme Court, by a majority of the appellant, Mr. Kennedy, is an experienced journalist with the Times. He has long been concerned to investigate and understand more about 3 inquiries conducted under the Charities Act 1993 by the Charity Commission in relation to an appeal, the Mariam Appeal, named after Miss Miriam Hamza, founded by George Galloway, MP, in 1998 and operated until 2003. The Charities Commission concluded that this was an unregistered charity. Some of the appeal funds had been used by Mr. Galloway on travel and political campaigning to end the sanctions in Iraq. Other monies had been received by other trustees as unauthorized benefits in the form of salary payments, and the source of some of the appeal funds was contracts breaching UN Iraq sanctions in circumstances where one trustee knew and Mr. Galloway may have known the connection. However, the Charities Commission decided on no further action on these matters. Mr. Kennedy maintains that the uses of funds were contrary to Mr. Galloway's original stated aim that appeal funds would be used to treat Miss Hamza. He views the 2 brief reports issued by the Charity Commission on its inquiries as leaving significantly unclear the basis on which it conducted the inquiries, the information upon which it acted, its communications with other public authorities, and its conclusions. The questions he has raised are important. The issue before the Supreme Court is whether Mr. Kennedy is entitled to seek further information on these questions from the Charity Commission under the Freedom of Information Act 2000, the FOIA. The Charity Commission maintains all such information is covered by Section 32, subsection 2, which makes absolutely exempt from disclosure information in any document placed in the custody of or created by a person conducting an inquiry, so that none of the further provisions of the FOIA can apply. The Court of Appeal, overruling the Information Tribunal, upheld this objection. The issue before the Supreme Court is thus whether the absolute exemption in Section 32(2) continues after the end of an inquiry. Mr. Kennedy submits, first, that it does not as a matter of ordinary construction; second, that if it were to, then it would be incompatible with his freedom to receive and impart information under Article 10 of the Human Rights Convention, with the consequence that this court should read Section 32(2) down under Section 3 of the Human Rights Act, so as to cease to apply either at all or at least as an absolute exemption after the end of any relevant inquiry. And third, that all else failing, the court should declare Section 32(2) incompatible with the Convention. The Supreme Court, by a majority of 5-2, dismisses the appeal and declines to grant the relief sought. Full majority judgments with which Lord Neuberger and Lord Clark agree are given by myself, Lord Sumption and Lord Toulson. There are dissenting judgments by Lord Wilson and Lord Carnworth. In the opinion of the majority, the construction of Section 32(2) in the context of the FOIA as a whole is clear, as is the case with information contained in court and arbitration documents covered by Section 32, subsection 1. So too here, the absolute exemption for information in inquiry documents under Section 32(2) continues, in the majority's view, after the end of the relevant proceedings for a prescribed statutory period of 30 years, since reduced to 20 years. In each case, however, it is an absolute exemption from disclosure provisions of the FOIA, not from disclosure generally. Section 78 of the FOIA expressly provides that nothing in the FOIA limits the power of a public authority to disclose information held by it. In the case of court and arbitration documents, the court has power to order disclosure. In the case of inquiry documents, the FOIA therefore directs attention to the regime governing the particular inquiry, here the Charities Act 1993. In these circumstances, even assuming that Article 10 is engaged by Mr. Kennedy's requests as he submits, there would be no basis for remoulding the clear language of Section 32, subsection 2. Rather, attention should be focused on the Charities Act 1993, which there would be no difficulty in reading so as to cater for any relevant Article 10 rights which do exist. Further, to read down Section 32(2) would in any event run contrary to the grain of the FOIA. On that basis, the appeal must be dismissed. However, the majority goes on to examine first the position regarding disclosure under the Charities Act 1993, and second whether Article 10 is engaged by Mr. Kennedy's requests. The Charities Act imposes on the Charity Commission objectives of increasing public trust and confidence in charities and enhancing their accountability. These link directly into its further duty to have regard to the principle that its regulatory activities should be proportionate, accountable, consistent, and transparent. In the context of the reports which the Commission has made on its inquiries into the Mariam Trust, these provisions create, in the majority's view, a strong public interest in openness and disclosure, to which effect should be given unless it be demonstrably outweighed by countervailing interests. The relevant balancing exercise would, of course, have to take account of, for example, the Commission's dependence on the cooperation of third parties, as well as any confidentiality or national or international sensitivity of the relevant information. There is no reason to think that the outcome of the balancing act to be undertaken under the Charities Act would be any less favourable from Mr. Kennedy's viewpoint than would be the case assuming Article 10 to be engaged. The majority, after analysing the present state of the authorities in the European Court of Human Rights, does not, however, consider that Article 10 is engaged so as to impose on public authorities a freestanding duty of disclosure of information independent of any domestic statutory right or obligation. But in the circumstances, that is irrelevant. The minority would have taken a different view on the last point and have concluded first that Article 10 does apply in the present circumstances, and second that on that basis Section 32(2) could and should be read down to cease to apply after the end of the relevant inquiries, so affording Mr. Kennedy a direct right to pursue a claim to the information he seeks under the FOIA.